Good afternoon, everyone. Thank you for joining us for another Beale & Company webinar, the next in the series of our regular construction law updates. Many of you are regular attendees and will be aware of the format for these by now. Thank you for joining us again. I would like to welcome the new attendees. This webinar, as this title slide indicates, is in relation to the new NEC4 suite of contracts, which were published on the 22nd of June 2017. This webinar also focuses on the NEC4 professional services contract for our consultant clients and friends. There is a lot of information on the internet and published articles by NEC and other law firms in relation to the new engineering and construction contract, or the ECC, but very little in relation to the professional services contract. So we hope this webinar is of use to you all today. I should also add that this is the first of a series of webinars to discuss the new NEC4 contracts. As I have mentioned, today we are focusing on the PSC for our consultant clients and friends. Tomorrow, my partners Tom Pemberton and James Vernon will be discussing the engineering and construction contract from a contractor's perspective. If you are interested and haven't registered for Tom and James's webinar, further details are provided later. As most of you will know, my name is Will Buckby and I lead the Projects and Contracts Advisory team at Beale & Company. I'm joined by Andrew Croft, an excellent associate in the team. The NEC4 follows the publication of various new suites of standard form appointments. The NEC is describing their changes as evolution, not revolution, suggesting that the changes are largely improvements to reflect market practices and in order to make the forms more consistent. This is similar to the approach adopted in the other standard forms. Today, we will explore whether the NEC's evolution, not revolution statement is true, and whether the changes to the PSC in particular are improvements or in fact expose the consultant to additional risk and liability. With this in mind, during the next hour, Andrew and I will be working through the agenda on this slide. In the first part of the webinar, we will provide a very brief refresher on the NEC contracts and consider some of the reasons for the introduction of the NEC4 suite. We will then touch upon the general changes such as stylistic changes or changes to structure, many of which apply to the PSC as well as other forms. We will then consider the key changes of the key features of the NEC4 PSC before looking at the key changes which are specific to the PSC. Here we will be focusing on the key risks and liability items which you as construction professionals will need to know about. We will follow this by briefly considering the other professional services contracts, the short form and the new subcontract. Finally, we will then give our view on the NEC4 PSC and the key points to bear in mind if you are asked to enter into the form, which I'm sure you will be, before concluding in the usual fashion. As an introductory comment, the more we read the NEC4, the more comments or views we gather, good or bad. What I mean by this is that this is obviously very early days in the life of the NEC4 and the PSC. Over the next few months, there will be further views made and positions taken, which will be worth considering. And given that the NEC4 suite is a new suite, we're expecting quite a few questions today. As usual, questions can be raised during this webinar using the interactive box on your screen, or do email us at webinars@beale-law.com, as stated on the slide. We will leave the questions to after the webinar, if you don't mind, and revert to each of you individually or collectively, depending on the nature of the questions. Right, let's start with a quick refresher on the NEC forms. For those of you who participated in our NEC3 webinar in February last year, you may remember this slide. It is our view that the NEC forms are the most common standard forms for construction and infrastructure projects, first published in 1993 and last updated in April 2013. The NEC suite includes a number of different forms and has been promoted in the public sector and by its use on significant projects, including most recently on Crossrail and HS2. In the time provided, I obviously do not intend to repeat the recent history and background information which is provided on this slide. However, what I think is useful by way of a recap is Peter Higgins, chair of the NEC4 Contract Board, and his preface to the NEC4 suite. This states, NEC was first published to facilitate and encourage good management of risks and uncertainties using clear and simple language. He continues, the NEC approach to managing contracts was endorsed in constructing the Latham Report, which was a government industry review of procurement and contractual arrangement in the UK construction industry. NEC has played a part in helping the industry do things differently and better. It has done so by introducing effective project management procedures into the contract itself. These require proactive management of risk and change and the day-to-day use of an up-to-date program. And as I say, that's quoted from the preface to the NEC4 suite. I think this is a good summary of the NEC's philosophy, which, as we will explain, is still at the heart of the NEC4 suite. As we mentioned earlier, the tagline for the NEC4 suite is evolution, not revolution. Peter Higgins also states that there were three key objectives in drafting NEC4. One, providing greater stimulus for good project management. Two, providing support for new approaches to procurement which improve contract management. And three, inspiring, a powerful word, increased use of NEC in new markets and sectors, such as their use internationally. Another aim of the amendments is to reduce the number of Z clauses being added to the suite. As we all know, it has become very common for clients, particularly in the public sector, to rewrite the relevant NEC form using lengthy amendments and Z clauses. So the new NEC4 suite, what's in it? There are now 16 contracts, as detailed on this slide. This includes 4 new forms, as well as historic forms such as the engineering and construction contract, the professional services contract, the term service contract, the framework agreement, etc., etc. NEC4 now includes new term services and professional services subcontracts, a new design, build and operate contract, and interestingly a consultation version of an NEC alliance contract. There is clearly a lot more to the NEC4 than just the PSC, which we're focusing on today, and the ECC, which is being discussed in the webinar tomorrow. The NEC4 alliance contract is much awaited, having been in the pipeline for many years. The alliance contract reflects increased use of alliancing in the UK, I suppose particularly by Network Rail and water companies as part of their AMP cycles. The consultation version is based on the Australian form, which has been adopted in the UK by Network Rail in a large number of schemes. The alliance contract is to be entered into by all the key players on the project, designers, contractors, and the client. It reflects a number of the key NEC principles, but as is common with alliancing contracts, includes no formal dispute resolution mechanism. This reflects the no blame, no claim culture typically adopted on alliancing projects, with all disputes to be resolved by what's called the Alliance Board. The consultation on the alliance contract is open until the 30th of November 2017, so watch this space. We might see this form being used on big infrastructure projects, along with the usual Z clauses, which have all become common in recent years. Now to the DBO contract. This is intended to enable the client to procure design, construction, operation, and or maintenance from one single contractor. This reflects the NEC seeking to expand into the EPC and the process plant market, where the use of forms such as the ICME is more common. Finally, the PSC and the TSC subcontracts. These have been produced to fill in a gap in the NEC suite. In many instances where a consultant has been required to appoint a sub-consultant, the PSC has been used for the sub-consultancy agreement and amended accordingly, or a bespoke sub-consultancy agreement has been used. As with the ECC subcontract, the PSC and the TSC subcontracts include very similar provisions to the relevant main contract form, with buffers included in respect of time periods and other provisions. The NEC claims these subcontract forms can be used with any NEC4 main contract. We will come back to the PSC subcontract later in this webinar. I'm now going to hand you over to Andrew, who is going to go into a bit more detail in relation to the changes included in the NEC4 forms.
Thank you very much, Will. I am now going to get into the nitty-gritty of the changes introduced in the NEC4 suite. We will now have a look at the changes which have been made across the suite as a whole. The basic structure of the NEC4 contracts has not changed, with each contract made up of the core clauses, a main option, secondary options W, X and Y, a schedule of cost components, the contract data, and if needed, any Z clauses. The key clauses under the NEC4 have the same general effect as under the NEC3. The underlying principles have not fundamentally changed. In relation to the structure, the changes which have been made include the introduction of new clauses and new secondary option clauses to reflect market practice, tweaks to the existing NEC3 position, and general changes to terminology and for consistency across the suite. The new provisions across the main forms in the NEC4 suite include an obligation not to do a corrupt act, which also applies to a subcontractor. This is also a ground for termination, and obviously reflects the Bribery Act 2010. Both parties now have a right to assign under the NEC4 forms, which is unlimited, other than that the client cannot assign to a party who does not agree to act in the spirit of mutual trust and cooperation. This does not necessarily reflect the typical market approach to assignment and is likely to be amended in practice. The NEC4 also includes a new process for a final assessment to be made following issue of the defect certificate or a termination certificate. This reflects the JCT approach to a final account. Under the PSC, the assessment is made by the service manager, which is a role I will come on to shortly. If not, the consultant can issue their assessment, following which the final payment becomes due, other than following termination. It should be noted that the assessment is conclusive evidence of the final amount due, unless referred to the senior representatives or adjudicator within 4 weeks of the assessment being issued. This condition precedent will need to be managed. NEC4 construction contracts, as opposed to, say, the professional appointments, also include a new secondary option, X22, for early contractor involvement. This includes a 2-stage process for the contractor to be appointed. The NEC had previously issued an early contractor involvement supplement, so this is not necessarily a surprise, but it reflects a general trend in the industry towards 2-stage tendering and early contractor involvement. Whilst this is obviously not included in the PSC, I raise this amendment to the ECC because it suggests that the NEC believes that consultants are increasingly working alongside contractors at an early stage, and that this may continue. Another secondary option in the construction contracts is X21, called whole life costs. This is perhaps misleading. It is essentially a value engineering mechanism, and is not an obligation to minimise whole life costs, which we see in, say, some network rail contracts. Again, this is not included in the PSC, but consultants who are appointed by a contractor when X21 is included in the ECC can expect a number of requests for assistance with value engineering, which will need to be reflected in the consultant's appointment. In my view, these changes are not significant and may not come as a surprise. They are not something to write home about. But now to something much more exciting. You may not be surprised that as Beale & Company's BIM guru, I wanted to focus on the new BIM secondary option, option X10. BIM has its own dedicated slide, although I will keep this brief, I promise. In the foreword to the NEC4 suite, Tony Meggs, Chief Executive of the Infrastructure and Projects Authority, which reports to the Cabinet Office and HM Treasury, states that the NEC4 contract embraces the digital changes that are happening in the construction industry, which will be central in creating a step change in performance. This may be setting the bar slightly high as to what the NEC4 can achieve, but the inclusion of option X10 is a positive step. It is the first attempt in a standard contract suite to properly address BIM other than simply referring to any BIM protocol. Option X10 refers to 2 main documents, the Information Execution Plan and the Information Model requirements, which are to be set out in the scope. This ties in with the 2 key documents required under PAS 11922, the BIM Execution Plan and the Employer's Information Requirements. Note that if option X10 is used, the information model and the rights in any information used to create or change the information model will be owned by the client, unless the information model requirements say otherwise. This is a commercial risk for the consultant. In addition, if clause X9 transfer of rights does not apply, ownership of the rights in other documents may not transfer to the client, so this could result in a position where the intellectual property rights in some documents are retained by the consultant, but the ownership of BIM-related information transfers to the client. This is unhelpful drafting. Option X10 provides for revised information execution plans to be accepted by the service manager. Note, however, that a revision of the information execution plan is not a compensation event in itself, unless the changes are as a result of a compensation event. This will need to be managed, and perhaps should be amended to allow for compensation events to arise in the event that revisions of the information execution plan are necessary. The liability position under option X10 is to some extent similar to the approach in the CIC protocol. Faults in an information model, which are not a defect, and faults in information provided by third parties are client risks, and therefore the consultant will be reimbursed any cost as a result. This might include issues such as data corruption, unless caused by the consultant failing to comply with the scope. This is positive. In addition, the consultant is only liable for faults in the information used to create the information model if it failed to exercise the skill and care normally used by professionals preparing similar information. Again, this is a very reasonable position. So, we welcome the changes in relation to BIM, although the intellectual property position should be handled with care. I said I would be brief. As well as the additional provisions I mentioned, the main forms of the NEC4 also tweak the NEC3 approach in some key areas. For example, in relation to programming, if the service manager, and as I mentioned earlier, I will come on to this role shortly, does not reply to a program within 2 weeks, and the failure continues for 1 week following a notice from the consultant, the program is treated as being accepted. However, if no program is referred to in the contract data, 25% of sums due can be retained until the program is submitted. This is even the case under the PSC. This will need to be managed. Although this is a real example of the NEC promoting good project management, the consequences are significant. In addition, the payment mechanism has changed in the NEC4. The client now has a right to be paid if the amount due reduces. In addition, if no application for payment is made, the amount due will not increase in that assessment date, but may decrease if the service manager's assessment is lower. It will therefore be important that applications for payment are submitted before each assessment date. I will discuss this further later in the webinar. The approach to compensation events has also changed in the main forms. Additional compensation events can now be included in the contract data, although we do not expect that many clients will take advantage of this. In addition, the concept of a dividing date has been introduced for when a compensation event is assessed. The consultant is entitled to its actual costs for work done by the dividing date and forecast costs for other work. The dividing date is the date the compensation event was notified for most compensation events, unless they are triggered by the service manager. The service manager also has a right to request a quotation for a proposed instruction. If that is not accepted, this is a compensation event, entitling the consultant to the costs of preparing the quotation. This again enables better project management by allowing the impact of a proposed instruction to be known before an instruction is issued, and provides some comfort that the consultant will not be required to expend significant resources preparing quotations without being paid. Other key tweaks to the main form include, rather than indemnities, the NEC4 forms make the parties liable for costs. This is perhaps intended to soften the relevant clauses, although, as I will comment shortly, the consultant's risks under the NEC4 PSC have increased. The early warning regime has also been upgraded. This is now more proactive, rather than reactive, in that an early warning register is prepared and an early warning meeting held at the start of the contract, rather than only in response to an early warning notice. This change again shows the NEC4 promoting good project management. The insurance requirements have also changed in the main forms. Any public liability policy must now include a cross-liability clause, so that the insurance applies to both parties separately. This should be discussed with your broker before entering into the contract if public liability insurance is required. I will look at some of the other insurance changes in the PSC later in the talk. The final general amendments are to the dispute resolution provisions. Firstly, the NEC4 includes a process for parties to refer a dispute to their senior representatives for resolution over a 3-week period. If option W2 applies, i.e. where the Construction Act applies, this process will only apply if the parties agree, which reflects the fact that the Construction Act entitles the party to a construction contract to adjudicate at any time. The NEC4 also includes a new option W3, allowing a dispute adjudication board to be appointed where the Construction Act does not apply. This is not an option under the PSC, but suggests that the NEC4 is taking a similar approach to, say, the FIDIC construction contracts in order to increase their use internationally. Now, I'll hand back to Will.
Thank you, Andrew. We're now going to focus on the NEC4 PSC. As we've mentioned, this is a webinar focused on consultant issues. The structure of the NEC4 PSC is very similar to that of the NEC3 PSC, with two notable changes. Firstly, the payment options are different. There is no longer an option for payment on a time charge basis, the old option E. This has been replaced with the cost reimbursable option. In addition, the term option, option G, this has been removed on the basis that for a term contract, the term services contract should be used. I also have rarely seen this option used in the NEC3 PSC. In addition, the schedule of cost components and the shorter schedule of cost components is now included in the PSC. This reflects the inclusion of the principle of defined cost in order to align the PSC with the ECC. Andrew's going to explore this further shortly. This amended contents page emphasises perhaps the limited changes which have been made to the NEC3 PSC. Andrew has already discussed some of these changes, such as secondary option X10, information modelling, BIM, and we will explore other significant changes to Core Clause 8, liability and insurance, and option X8, undertakings, to others shortly. Other changes, such as Core Clause 2, the consultant's main responsibilities, and secondary options X11, that's termination, and X12, collaboration, are changes in structure and terminology only, and therefore have no substantive effect on the PSC. Note in the middle of the slide that the parent company guarantee secondary option X4 now provides that a guarantee is to be provided by the ultimate holding company unless an alternative guarantor is accepted. This is obviously not helpful, particularly as a number of you understandably avoid providing ultimate holding parent guarantee, so this will need to be managed. So as a contents page demonstrates, the key structure of the NEC4 PSC is very similar to the NEC3 PSC. Similarly, the fundamental principles which underpinned the NEC3 PSC also underpin the NEC4 PSC. The duty of care remains the same. The consultant's obligation is to use the skill and care normally used by professionals providing services similar to the service. The project management regime is also identical, almost identical. For example, early warning notices are still required, and failure to give one affects the consultant's rights if a compensation event arises. In addition, the detailed and administrative program obligations remain with some tweaks. Also, the consultant's only right to additional payment and an extension of time is still under the compensation event procedure, with the consultant losing this entitlement if a compensation event is not notified within 8 weeks of becoming aware that the event has happened, a key way in which the NEC forms encourage good project management. Adjudication and the service of a notice of dissatisfaction remain a condition precedent to referral of a dispute to the tribunal. As with the NEC3 PSC, the NEC4 PSC remains administrative, much more so than a typical consultancy appointment. And for this reason, we say, and frequently said in relation to the NEC3 form, that it remains a contract not to be left in the drawer.
Thank you, Will. I will now look at some of the detail of the changes to the PSC, starting with the new important role, which I mentioned a few times earlier, under the PSC, that of the service manager. The service manager administers the contract on the employer's behalf under the NEC4 PSC. The service manager role is very similar to that of the project manager under the ECC, and is a central role under the NEC4 PSC. The service manager is required to act in a spirit of mutual trust and cooperation, gives notices and instructions under the contract, accepts programs, and assesses payment and compensation events. The identity of the service manager should be clarified at the start of any contract using the NEC4 PSC. It should be noted that the client can replace the service manager during the course of the contract. The role of the service manager is a key change to how the PSC operates and will need to be managed carefully. It's a change which will have a direct impact on approach and conduct under the PSC, and we have queries about how appropriate it is in a service contract. It is perhaps likely that the service manager may just end up being the client or one of their employees. I don't think that's quite the intention of the NEC4. The liability position under the NEC4 PSC has changed quite a bit. Unfortunately, this is probably to the consultant's detriment. Starting with a positive point, clause 20.3 of the NEC4 PSC limits the consultant's liability for defects to where it has failed to exercise the reasonable skill and care. As a result of the definition of defect, which is referred to on the slide, this does not mean that the duty of care in the PSC now applies to all obligations under the PSC. However, there has been a notable trend recently for clients to include onerous and strict obligations, or perhaps additional obligations, in the scope. So this does provide some real comfort to the consultant. We do, however, expect that clause 20.3 will be commonly deleted by clients. This should obviously be resisted if possible. The approach in clause 20.3 is consistent with the approach taken in the ECC secondary option X15 in the NEC4 form in relation to the contractor's design. This formally stated that the contractor was not liable for defects due to design if they proved they used skill and care to comply with the works information. The NEC4 ECC approach, which no longer refers to the works information and does not shift the burden of proof to the contractor, should provide greater protection against fitness for purpose arising under the ECC. This will provide some comfort for consultants appointed by contractors under the ECC if option X15 is included. And if you are appointed by a contractor whose construction contract is in the form of the ECC, it is always worth trying to persuade them to get option X15 included if you can. However, as I have noted, the new PSC does unfortunately expose the consultant to additional risk and liability to the NEC3 PSC. Firstly, whilst the NEC3 PSC required the consultant to indemnify the client against any infringement of the rights of others, for example, this would include intellectual property claims, under the NEC4 PSC, a number of risks are consultant liabilities. The consultant liabilities include costs incurred by the client as a result of failure to exercise the consultant's duty of care, and death or personal injury to the consultant's employees. These are perhaps reasonable risks for the consultant to bear. However, in addition, any claims and proceedings from others and costs payable to them as a result of the consultant providing the services is a consultant liability. As you may know, under the NEC PSC, providing the services means to do everything necessary to complete the service in accordance with the contract. A risk is not a consultant's liability if it is a client liability. Client liabilities in Clause 80 include claims which are an unavoidable result of the service or which are caused by third parties employed by the client or by the client itself. This means that essentially the consultant bears the risk of all avoidable claims as a result of the services, even if it has complied with the contract, and also of claims which are caused by third parties other than those employed by the client. For example, if they were caused by a subcontractor or a member of the public. This is an additional risk and wider liability than arose under the NEC4 PSC. The consultant must pay any cost which the client is liable to pay as a result of a consultant liability, so this is a real risk. This underlines the importance of including the additional limits of liability in option X18 in respect of indirect and consequential loss and defects found after the defect state if you can. The NEC4 PSC does not include clause 82.2 of the NEC3 PSC, which was a shortened net contribution clause. The client's right to recover costs as a result of a consultant liability is reduced to the extent that an event for which the client is liable contributes to those costs. However, this has a more limited effect than clause 82.2 did. For example, if the costs are jointly caused by a subcontractor or a member of the public, it would have no effect. In addition, if there was a claim for something which wasn't a consultant liability but was a breach of contract, this contribution position would not apply. This is unfortunate drafting. The payment regime under the NEC4 PSC has also changed and is now a lot more administrative than it was under the NEC3 PSC. Under the NEC3 PSC, the consultant simply submitted an invoice, which was the payment notice under the Construction Act, with the final date for payment 21 days after the invoice was submitted. Under the NEC4 PSC, the consultant is now required to submit an application for payment before the assessment date. The service manager then certifies payment within 1 week of the assessment date, with the service manager's certificate, the payment notice under the Construction Act. As I mentioned previously, when discussing application for payment, if an application for payment is not submitted before the assessment date, the consultant's entitlement to payment will not increase, but may decrease. Following the service manager's certification, the consultant must then also submit an invoice within 1 week of the service manager's certificate in order to be paid. Failure to submit an invoice will now delay the final date for payment, as this is now the later of 14 days from the application date and 7 days from the submission of an invoice. This means that the consultant has much less control over the payment process, as a service manager has 2 bites at the cherry to say the consultant is being paid less: a certificate and then a pay less notice. This payment process is also very administrative. Although this is not uncommon in bespoke appointments, the NEC4 PSC is a standard form, so this will need to be managed carefully by your businesses. In particular, following the recent cases on smash and grab adjudications, the payment notices generally, it is fundamental that you all understand and comply with the new regime in order to maximize your payment entitlement. The NEC4 also takes a different approach to valuing sums due to the consultant, which I will explore now. There is no longer an option for payment to be on a time charge basis, by reference to hourly rates, as was the position under the NEC3 option C and E. Under the NEC4 PSC, payment under option C and E is based on defined cost. Defined cost is also used to assess compensation events under all options. Some of you may be familiar with the principle of defined cost, as it was included in the NEC3 ECC. In option A, defined cost for the purpose of compensation events means the cost of components in the short schedule of cost components. In option C and E, the full schedule of cost components is used to determine defined cost, and disallowed cost is deducted from those costs. Disallowed cost includes, amongst other things, costs which are not justified by the consultant's accounts and records, the costs of correcting defects after completion, and the costs of correcting defects caused by not complying with a constraint in the scope. The concept of disallowed cost gives the client and the service manager grounds to deduct sums from those claimed by the consultant, which may otherwise have been recoverable. For example, the requirement that the costs are justified is wide and could well be exploited. There is also a risk that, as we have seen with the NEC3 ECC, clients will seek to widen the scope of disallowed costs to further limit the sums recoverable. Any amendments which do so should obviously be resisted. There is also now a process for finally assessing defined costs under the options C and E, and a requirement to maintain records during the course of the contract. This is a further administrative burden on the consultant, although if the consultant's assessment is not rejected by the service manager and a further notice is provided by the consultant's assessment can be treated as correct, so this could be used to your advantage. Whilst this makes the NEC4 PSC more closely aligned with the ECC, it requires the consultant to take a very different approach to applying for payment. For example, the schedule of cost components requires a detailed breakdown of the sums paid to employees used in providing the services, including, for example, details of any bonus arrangements, to be provided to show the costs incurred by the consultant. Any profit must then be recovered in the consultant's share, if option C applies, or in the fee. Some consultants have expressed concerns about having to disclose this level of information, particularly given that the relationship between their fees and the sums paid to staff has traditionally been confidential. This new approach to valuing payment will need to be considered and understood by your business before entering into the NEC4 PSC. And your business should familiarise itself with the schedule of cost components and the scope of disallowed cost. The fee percentage should also be considered carefully to ensure that the expected margin is recovered on the services. Generally, the NEC4 PSC takes a much more contractor-style approach to payment than a professional services contract would typically take. As those who have worked for contractors previously will know, this is a risk. The position under the NEC4 PSC has also changed fairly significantly in relation to a few other key areas: subcontracting, insurance, and termination. Acceptance is now required before appointing any subconsultant, which are now referred to as subcontractors, under the NEC4 PSC. Whilst this is not unusual, if a subcontractor is appointed for substantial work before acceptance, this is now a ground for termination, so this will need to be managed very carefully. The NEC4 also includes additional insurance obligations in Clause 84, including a requirement that a certificate signed by the insurer or broker is submitted before the starting date, after the defects date, and on each renewal of the policy. If they are not provided, the client can take out its own policy and recover the costs from the consultant. So it is very important the certificates are provided when required. This underlines the increased administration required under the NEC4 PSC. In addition, the consultant is required to take out any additional assurance included in the contract data. This will need to be considered carefully to ensure that any additional insurance required is acceptable. The client is also required to take out insurance stated in the contract data under Clause 86 of the NEC4 PSC. Whilst this could provide some comfort for the consultant, we think that it will be rare for the client to agree to take out any insurance in the PSC. This is more common in construction contracts rather than in a services appointment. Another risk under the NEC4 PSC is that the grounds for the client to terminate have widened. They now include a substantial failure by the consultant to comply with its obligations, which has not been corrected within 4 rather than 8 weeks of a notice from the client. In addition, if the consultant substantially hinders others or substantially breaches a health and safety regulation, and again this is not remedied within 4 weeks of a notice, the client has a ground to terminate. In addition, the consultant's right to terminate for non-payment has been limited. The non-payment must now continue for 13 weeks, not 8 weeks, although following termination for non-payment, as well as for insolvency or client default, the consultant is entitled to recover the fee percentage of any of the prices which are not unpaid. The new approach to termination will need to be managed and considered carefully under the NEC4 PSC. The final changes which I will discuss are in relation to liability to third parties, which is an increasing risk under professional services agreements. Firstly, Option 8 of the NEC4 PSC, undertakings to others, requires the consultant to provide any undertaking to a third party which is included in the scope, rather than simply collateral warranty agreements. The contract data will set out who those undertakings must be provided to. If Option X8 applies, it will therefore be very important to limit the individuals or classes listed in the contract data and to review the required form of undertaking very carefully, as it may be something different to a collateral warranty or it could be onerous, and any undertaking provided will expose the consultant to additional liability. In addition, secondary option YUK3 of the NEC4 PSC, in relation to the Contracts Rights for Third Parties Act 1999, now allows classes of beneficiary identified in the contract data to be granted the right to enforce the terms stated in the contract data. As with any appointment, the identity and classes of the beneficiary should be limited if YUK3 applies. Each additional beneficiary who can enforce the contract will increase the consultant's potential liability. Rather than simply listing the terms in the contract data, a preferred approach and a more market standard approach would be to refer to a third-party rights schedule, which sets out the clauses the beneficiary can enforce and makes clear that the consultant's liability is limited to that which it would have under the appointment, and that the consultant can rely upon equivalent rights of defence, for example. So that concludes my canter through the key changes in the NEC4 PSC. I will now hand back to Will, who will consider some of the other NEC4 professional services agreements.
Thank you, Andrew. The PSC is not the only form in the NEC4 suite which consultants can use. Some of you may have experience of the NEC3 professional services short contract, which in fact is not used that often, but is, however, for example, included in the Highways England Collaborative Delivery Framework. There is also the new professional services subcontract. The professional services short contract, which is much briefer than the PSC, and is intended for use on smaller scale projects where sophisticated management techniques, and those are words from the NEC, are not required, has had very limited changes. The general changes mentioned by Andrew earlier regarding, for example, corrupt acts apply, as do the changes regarding client and consultant liabilities. There are others, but these are the main changes. As noted earlier, the PSS, or the Professional Services Subcontract, this is a new form. It is one which we think should be welcome because of the obvious gap in the NEC suite in relation to sub-consultancy agreements. The NEC state that, and I quote, "This contract should be used for the appointment of a subcontractor to provide professional services to a contractor or a consultant who has been appointed under an NEC4 main contract." So it does specifically mention an NEC4 main contract. The PSS, as you would expect, is very similar to the PSC. It takes the majority of the PSC provisions and effectively turns the PSC into a sub-consultancy agreement. For example, there is an obligation to use the skill and care normally used by professionals providing services similar to the subcontract service. And amongst other things, and these are just examples, the PSS contains detailed drafting relating to the early warning regime, programming, compensation events, and a section on liabilities and insurance. I don't think there's any surprises here. The PSS contains time buffers, as you would expect, to allow for a flow down, which is typical in sub-consultancy arrangements. There are some examples on the slide, the third sub-bullet. Further, the PSS will terminate if the main contract terminates. However, the PSS really lets the side down by not including typical drafting in sub-consultancy arrangements, which provides that the sub-consultant shall not cause or contribute the main consultant or the contractor to breach the main agreement, and that the sub-consultant shall comply with the relevant provisions of the main agreement as if they were set out in the PSS. Whilst this is onerous on consultants, this drafting, in my view, in most cases, is going to be added to the PSS as a Z clause, and this also may encourage other amendments too. As with the NEC3 forms, the NEC has consolidated a number of useful tools and pointers onto the websites identified on this slide. The NEC4 products link includes more detail on the NEC4 contracts, links to where the new suite can be purchased, of course, details of texts or books on the NEC, amongst other things that I think is well worth a look, and something that Andrew and I have looked at in preparation for this webinar. So that is our comments for consultants on the NEC4 suite, and specifically the NEC4 professional services contract. We've explained the main changes and where appropriate provided some guidance. What do Andrew and I think about the new NEC forms and the PSC? There are quite a few changes which have been introduced for a variety of reasons. These are just our views. The amendment in clause 20.3, which limits the consultant's liability for defects to where it has failed to exercise the required level of skill and care, is positive, as is new option X10 in relation to BIM. As our BIM guru, Andrew, is pleased with this new option. The PSS is also a welcomed addition to the family. But I just feel that the amendments have made the PSC more onerous and more administrative for consultants, and in some way brings in contractor type provisions to a consultancy appointment. Liability for third-party claims, no net contribution clause, a more administratively demanding payment regime, ultimate parent company guarantee, the requirement to submit applications and invoices, disallow cost. There are others. Were these changes absolutely necessary? In my view, I don't think so. The introduction of the service manager might be helpful for major schemes, but do we really need one for a typical design or other services commission? In my view, it's only going to add to the cost of using the NEC4, a further cost, in fact, given that consultants, as we understand it, typically price an NEC contract higher than others because of the administrative burden, and so they should. A change for the good, again, and unfortunately, I don't think so. But we can't be too negative about the NEC4 suite. And look, I'm a big fan. What is important is that the traditional project management mechanisms included in the PSC and the main forms in the NEC4 suite obviously remain. And if you don't leave your contract in your drawer and you use it, especially these project management tools, you really will be much better off. Before we finish, just wanted to plug a couple of webinars. One we mentioned at the start. So Tom Pemberton and James Vernon, as I mentioned, are delivering a webinar on the ECC for our contractor clients tomorrow. If you would like to attend, please do email the address on the slide. James Hutchinson is delivering a webinar on the 2nd of August on the GDPR. Details of James's webinar is on the slide in front of you. Please do register if you wish to join James. So that's it from me and Andrew. It remains for me to say thank you for listening to us. I hope that the webinar has been useful. If you have any queries in relation to any of the items we have discussed, or on the PSC or the new NEC4 suite generally, please do not hesitate to get in contact with us. We will circulate a copy of the slides and this recording very shortly and in the usual fashion. Once again, thank you for listening. Goodbye.